All right, let's go ahead and get started. My name is Alexandra Bradbury. I'm the editor of Labor Notes. And Labor Notes, in case you don't know, is a magazine and an organizing project. It's been around since 1979. Aims to be the voice of the rank and file, putting the movement back in the labor movement. And that means we publish a magazine, we publish books like the many that Robert M. Schwartz has published over the years, and we organize conferences and webinars like this, and bring workers together to build strategies, exchange information, teach each other how to build more of a fighting labor movement. So welcome. So glad you all are here today. Looks like we have 90 people here on Zoom, and the number is still climbing, and I know there are more people watching on Facebook as well. So in a moment, I'm going to introduce our speaker tonight. But before I do, I want to make a plug. Everything you'll hear tonight is covered in Chapter 4 of this book, The Legal Rights of Union Stewards by Robert M. Schwartz, which is available online at the Labor Notes website. I'll wave that again later, but labornotes.org/store, tremendously useful books. There's nobody like him. Mr. Schwartz will be taking questions in the middle of the presentation and then again at the end. So as you think of them, you could go ahead and type them in the Q&A, not the chat box, but the Q&A, or you could raise your hand, and we'll take a look at those when we get to that point. All right, so, and this session is being recorded. You are not being recorded. You're not visible, just the speaker and the presentation, but a video will be available afterwards. So you can share it with your fellow workers. So without further ado, I imagine that many people viewing are very familiar with who Robert M. Schwartz is, but for those who aren't, he practiced labor law on behalf of unions for more than 40 years in Boston, Massachusetts. Before entering law school, Mr. Schwartz was a member of several unions, including UAW and SEIU and the Teamsters. And in one workplace, a South Boston warehouse, he helped organize a Teamsters local. He was also a leader in a successful campaign for rent control in Cambridge, Massachusetts. And since his retirement in 2016, he has continued to write for Labor Notes, including putting out new editions of his very popular series of labor law handbooks. So these include The Legal Rights of Union Stewards, but also Just Cause, the FMLA Handbook, How to Win Past Practice Grievances, No Contract, No Peace, and the Labor Law Source Book. All those books are available at labornotes.org. And today's webinar is based on Chapter 4 of Legal Rights of Union Stewards, which costs $20 plus postage from labornotes.org. So I'm going to go ahead and begin the slideshow and let Mr. Schwartz take it away.
Good. Well, thank you for coming to this Zoom seminar. I wish I could see you in person, and we could have probably a better exchange. But this is how things are done in 2020. And I'm sure you've been through many Zoom seminars, and either you like them or you hate them. The topic for today is union information rights. And this is the third of the webinars that I've been presenting. The first one dealt with Weingarten rights. The second one dealt with just cause. This one will deal with union information rights. And there may be a fourth, but we haven't determined the topic for it yet. I enjoy talking about this topic because, for the most part, this is an area of US labor law which is still favorable for unions. As you know, US labor law covers many different areas, such as organizing, bargaining, striking. And in some of those areas, the recent developments have been very negative in terms of decisions from the state and federal labor boards. And what rights we used to have or we thought we had no longer apply. However, when it comes to information rights, for the most part, the Trump Labor Board has not aimed its weapons directly at that topic. There are very few decisions from the Trump Labor Board reducing the rights that unions have to obtain information. Although I think that if they get 4 more years, I think there are some areas that they are definitely going to go after. And this was true, by the way, under the Reagan, when President Reagan was in office, he had also a very right-wing labor board, which weakened union rights in many areas, such as striking and bargaining. But also, it didn't do that much damage to the topic of information rights. Somehow, this topic seems to survive even the most right-wing labor boards. So it pays for us to study it and to learn it and to apply it. For the most part, we've had a lot of success in pursuing demands for information from the employer. At least we're often able to get the information after some back and forth between us and the employer, perhaps filing a labor board charge or 2 labor board charges or something like that. And eventually the employer becomes educated to his obligations or its obligations to provide the information. Unions have done fairly well at the labor board. We often win our cases. We often find that if we don't get the information that we've asked for and we take it to the labor board pretty much comes out on our side, either issues a complaint against the employer and sort of forces the employer to provide the information, or negotiates a settlement, in which case we get the information that we're looking for. So I encourage unions to be very aggressive in this area. We can set the employer back on its heels frequently if we exercise our rights. So let's go to the first slide. Next. So I think as a general rule, you could say that a union is entitled to information in 4 major areas. The first area is information that we want or we need to police the workplace, to monitor the contract, to check on the employer, to find out what's going on, to get answers as to why the employer is making certain changes, to determine whether there's a need for us to go any further in terms of filing grievances. So this is an area which I think a lot of unions don't. We'll go through a number of examples of policing the workplace, and you might pick up a couple of ideas that you want to apply in your workplace. The second big area where information requests come in is in the area of grievances. And it's the most, I would say, I guess you could say it was the most common context in which to file an information request. We're entitled to request information in order to investigate whether to file a grievance. If we do file a grievance, we're entitled to information that we would like to have or we need to present the grievance at a grievance meeting. And that includes first step and a second step and maybe a third step. And of course, a fourth step if we decide to take the case to arbitration. The third major area where we can ask for information has to do with midterm changes. And this is a somewhat dicey area because the rules have changed. Up until about a year ago, we had strong rights to request information to bargain over midterm changes. Midterm changes are changes outside of the contract, changes in which the employer brings in new technology, changes practices, scheduling practices, makes changes that are not directly contrary to the contract. They're not covered by the contract. And we exercise our right to demand bargaining before that change can be put into place. And in the past, when we did that, we always asked for information. Because if we're going to bargain with you over your midterm change, we want to know why you made the change, what were all of your reasons? What research you did? What were the cases that led you to make the change? And we would submit oftentimes extensive requests for information. But we have a problem now in this third area, because the Trump Labor Board issued a decision about a year ago called MV Transportation, and it enacted wholesale changes in midterm bargaining obligations. Essentially, what MV Transportation said is that if the contract has a management rights clause of anything more than simply maybe a simple 3 or 4 words, management shall administer or run the enterprise. If it has any kind of a real management rights clause or any kind of a real zipper clause, that pretty much it was free to make changes during the term of the contract without bargaining with the union. So this was a real blow for unions. It took away a big area of our engagement with employers during the life of the contract. And as it relates to requests for information, if we can't bargain, if we're not allowed to bargain over a change because somehow that change is encompassed in the management rights clause or in the zipper clause, then we don't have a right to request information. So for those of you who have management rights clauses or zipper clauses, you probably have lost the ability to bargain, and you've also lost the ability to request information when the employer decides to make a change that's within the general ambit of the management rights clause or the zipper clause. The fourth major area that we request information is when we bargain our collective bargaining agreement every 2 years, every 3 years, every 4 years, or when we bargain a new collective bargaining agreement for a new bargaining unit. Then, as we all know, we're going to submit extensive management rights, extensive information requests, 10, 20, 30, 40, 50 items perhaps, in order for us to intelligently come to the table and to deal with what the employer proposals and to present our own proposals. Let's go to the next slide. Who enforces the duty to provide information? Well, it depends on whether the union is a public sector union or a private sector union. If the union is a private sector union, a factory or other for-profit business, then that union will come under the jurisdiction of the National Labor Relations Board, the NLRB. And the NLRB enforces the obligation to provide information and issues orders against employers to provide the information or to take other action if it fails to adhere to its obligations. In order to get the National Labor Relations Board attention or to get them to act, we file unfair labor practice charges at the NLRB. We file those charges within 6 months of when the employer denies our request for information. Within 6 months of the day that the employer announces that it's not going to provide the information or takes other actions that indicate that that's going to ignore the union request or deny it. If we're a public sector union, if we represent employees of the state, city, town, then we're going to take our charge to the State Labor Board. And they have different names in every state. For the most part, most of the state labor boards follow the NLRB in this area of law and enforce the obligation to provide information. They have different procedures. They may have different remedies, but the law is pretty much the same. And then there's a fourth labor board, which I didn't put on the screen, which is called the Federal Labor Relations Board, Federal Labor Relations Authority, FLRA, and that provides coverage for federal employees of the Treasury Department, of the Justice Department, or whoever, and they would take their unfair labor practice charges to that board if they request information and they don't get it. Next. Just as a general discussion, why do we file information requests? What are the benefits of having an aggressive posture when it comes to information requests? Well, the first benefit is kind of common sense. In the end, we often obtain information that helps us present a grievance or helps us when we bargain the contract. So the information actually is useful to the union, and that's why we ask for it. But there are other reasons to file requests for information beyond the obvious of getting the information for a grievance or for bargaining. And I would suggest to you that these other goals or benefits are very important for the union. For example, number 2 says to impose a burden on management for violating the contract. So what I'm thinking about here is that for the most part, when management violates the contract and we file a grievance, it's not a very difficult, we don't make things that hard on the employer. The employer has to meet with us, maybe has to meet with us twice or even 3 times. Maybe has to meet 20 minutes, 30 minutes. Each time hear our arguments as to why the contract has been violated. And in the end, the employer either settles with the union or doesn't settle. It's not a difficult process. It's about an hour, 2 hours worth of work for some HR personnel. The unions which are aggressive on requests for information make a much heavier burden on the employer. The unions which are aggressive in this area will file an information request, also called an RFI, request for information. They'll file an RFI on every grievance that they file. That is, as soon as they file that grievance, they will either attach an information request to the grievance, or they'll file an information request within a few days after the grievance. And that information request will have not 1 or 2 items requested, but will have a litany of requests, 5, 10, 15. The union will sit down and develop those requests. Sometimes they'll do it by bringing together the officers or stewards or the employees involved and have a group discussion. What demands should we make on management that would be relevant to this grievance? In any case, they submit a detailed information request. Then they wait and see if management complies with the request. Now, if management comes back and actually provides answers to all 12 or 15 of the requests, that's fine. But of course, we know that's not going to happen. In some cases, management will come back with answers to maybe only 2 or 3 of the requests. Maybe in some cases, they'll come back with 5 or 6. But an aggressive union will not be satisfied with a partial response. If that union requests 10 items on its information list, it expects to get 10 answers. Each request is something that they feel is relevant to the grievance, that is important for them to have in order to present or argue the grievance, and they're not going to give that up. So if they get back an answer in which the employer provides, let's say, 7 out of 10 answers, that union doesn't just say, wow, that's great. We didn't even expect to get 7. That union says, wait a second. Thank you for the 7, but where's the other 3? And the same thing would apply if the employer comes back with 9 out of 10. An employer which answers only 9 out of 10 still has not answered a relevant request for information. And an aggressive union will put the screws on management for the 10th item. So if the union carries on in this way over and over and over time, or maybe I should say, if the union will object to not getting the items that it asked for. And when it makes that objection, it will wait a week or 2 weeks. And if the employer doesn't come through with the requested items 7, 8, and 9, or 8, 9, and 10, that union will file a unfair labor practice charge with the NLRB or with the state labor board. And they will interact with those labor boards to try to convince them to file a complaint against the employer and to schedule a hearing in front of an administrative law judge who can issue a final and binding order on the employer to provide the information. So what's the net result of all this? This employer knows that when he violates, or when it violates the contract with this union, with your union, it doesn't just have to sit down with you 2 or 3 times, 20 minutes at a time. In addition to that, this union is going to give him a list of 15 requests for information, many of which are quite detailed, many of which require the employer to go and do research within its records, many of which might require the employer to present to the union correspondence between the employer and contractors, or correspondence between communications between the employer and its supervisory or managerial staff. In other words, correspondence they don't want to see the light of day. So that this union is going to give them a very hard time. It's not just 15 or 20 minutes to come to a grievance meeting. It's hours and hours needed to respond to the request for information. And then it's hours and hours to go down to the NLRB to meet with NLRB investigators to explain why they didn't answer all of the requests. And then it's hours and hours after that to prepare for a hearing on an unfair labor practice before an administrative law judge. The net result of all that is that violating the contract is now much more burdensome for the employer, much more costly in terms of time, much more embarrassing in terms of the exposure of documents, much more unpleasant. And that gives the union leverage. If the employer knows that violating the contract is going to lead to difficulty, expenses, exposure of personal information or private information, or what they would like to call confidential information, that gives us leverage. And that employer is going to think twice before he continues to violate the contract. The third on the list here, the third benefit from being aggressive in filing information requests is the notion that if the employer does not answer your information requests, then that has certain legal consequences. One of the legal consequences is that that employer cannot legally declare an impasse in bargaining. And this would be true, by the way, in midterm bargaining, which, as I've explained to you, is not going on very much anymore. But it's certainly true in contract bargaining. Contract bargaining means that the employer meets with the union on several occasions, 5, 10, 15 occasions, but at some point, the employer is allowed to declare impasse if there's no meeting of the minds on the contract. And once the employer declares impasse, if there really is an impasse, the employer is allowed to implement its last best proposals. And I think we all know that that's a very unpleasant situation for the union. We want to prevent the employer from declaring impasse, from being able to declare impasse, because we don't want the employer to implement its final offer. One of the most effective ways we've found to prevent an employer from declaring impasse is by submitting difficult to answer information requests in the course of bargaining. Information requests that require the employer to give us information which it would like to consider confidential, financial information, other types of information which the employer doesn't want to give the union. If we can formulate those types of requests, and if the employer, true to form, ignores the request or denies the request, then from a legal point of view, that employer is not able to declare a lawful impasse, which means that it cannot implement its final offer. Now, that doesn't always work out for us, and sometimes the labor board will still declare impasse or determine an impasse despite the fact that we say that they didn't answer our information request properly. The employer says otherwise, the board may go with the employer, but it gives us a basis to make an argument. And sometimes we do win the argument. And it's something very important in any contract bargaining to think ahead. How can we devise and come up with some information requests that they're going to have a hard time answering, or they're not going to want to answer, and that will give us the basis, perhaps, to avoid impasse. In a similar way, there's a benefit from filing information requests in the context of bargaining a contract, because an information request can lay the basis for an unfair labor practice strike. I think probably most of you know that, at least in the private sector, where strikes are lawful, there are two types of strikes, two categories of strikes. One is economic strike, one is unfair labor practice strike. The main difference between these two types of strikes is that when you have an economic strike, which is most strikes, the employer is allowed to hire permanent replacements, scabs, during the strike, and to displace the union labor force on a permanent basis, or at least on a long term, and then probably in many cases on a permanent basis. When we are on an unfair labor practice strike, an employer is not able to hire permanent replacements. Or if it hires permanent replacements, it's going to have to, it may call them permanent replacements, but it will have to let them go when the strike is over, when the union comes back to work. So we certainly would prefer that our strikes be unfair labor practice strikes. One of the ways to shape your strike as an unfair labor practice strike is to point to requests for information that the employer has not answered or has answered in part, and to take the position that because the employer failed to answer our information requests, which were submitted in the course of bargaining, we were not able to resolve the contract. We were not able to come to an agreement. In that context, the strike is sometimes labeled an unfair labor practice strike. And then the fourth benefit from filing requests for information in the course of bargaining is that if the employer does fail to answer our bargaining requests, our information requests in the course of bargaining, then theoretically anyhow, it's not allowed to declare a lockout. That if it declares a lockout, that's not a lawful lockout. That's an unlawful lockout. We would generally prefer that the employer not declare a lockout, although there are some advantages to us from a lockout, which I cover in one of my books. But generally, we don't want the employer to declare a lockout. And one of the ways to discourage that is to file information requests that the employer fails to answer. Okay, next. Yes, just get to some nitty gritty. When we file information requests, does that request have to be in writing? Well, the answer is no. Information requests can be made in an oral fashion or verbal fashion. It can be made during a grievance meeting. You might be arguing the grievance. The employer refers to some document or some record as supporting its position. You want the record. You immediately say, well, we want a copy of that record. That's an oral request, but it's a request for a document. That is a legitimate request for information. And the employer has to provide the information in a prompt fashion. Now, of course, the problem with an oral request is that in many cases, the employer denies that you made the request or insists that you made a different request than the request that you say you made. And consequently, we always say that you can make the request orally at a grievance meeting or at a bargaining session. You should follow that up with a written request. And you should follow it up by saying, as you recall, in the grievance session today, the union requested the following personnel files of the following employees. And then we list the names. We are asking that you provide that information within the next 10 days. So now we've got it in writing. We've got a time. We put a schedule in there, a deadline, and it puts us in a better position to follow up on our request. Let me say at this point a couple of pieces of advice. My suggestion to you in the grievance process, when we're asking for information relative to grievances, is that after every grievance meeting, that you get together, that the union gets together gets all the officers who are at the grievance meeting, gets the grievant, maybe some witnesses, who's ever part of the group that's pushing forward this grievance, gets them together in a room and says, okay, let's go over what happened today at the step 2 meeting. And you might have a discussion on what happened, the good, the bad, what you could have done, what you should do at the next meeting. But as part of that discussion, I'm recommending that the union say, okay, we need to go over this meeting. Did anything come up at this meeting today? Did the employer make any reference at this meeting today to any facts, any documents, any records that we can now legitimately demand as part of an information request? Because if the employer does make certain assertions at that in the grievance process, he's got to back that up by providing additional information. For example, if you're at a grievance meeting and a worker has been suspended for insubordination, and you are arguing this and that about what happened, and in the course of that meeting, the employer says, well, we're not talking about Prince Charming here. This worker has been a pain in our butt for years. There's so many things that he's done wrong. I can't even tell you. He's refused instructions. He's organized. He's come back late from breaks. He's done poor work. He's made mistakes. He's cost us money, et cetera, et cetera. This is a common exchange at a grievance meeting. Well, if that is what has happened, what's our next step from the point of view of request for information? We come back to the employer and we say, well, at that meeting, you said that this is not the first time that this worker has committed, has been insubordinate or has been fresh or has been profane. If that's true, give us the data, give us the information on each event, give us the date, the place, who was involved, each incident that you claim represents bad work or bad attitude or some negative aspect of this worker. Certainly, if the employer was to say something at the meeting that other workers have complained about this worker, well, in our request for information following that meeting, we want the names of each person who made these so-called complaints so that we can go to them and see if they made those complaints. And if they didn't make those complaints, we're going to come back at you and explain that you are operating on false information here. If you imposed a suspension on this worker because you felt that this was the 5th or 6th time something had happened, well, as it turns out, this was the first time it happened. So consequently, obviously, your penalty was too severe because you based it on facts that turn out not to be true. So all I'm saying is that after the grievance meeting, you develop a request for information for each grievance meeting. At the end of each grievance meeting, we submit a fresh information request, because after all, we're not limited to one information request per grievance. We are allowed to file multiple information requests for the same grievance, as long as they're for different information. And the same thing goes for bargaining. My suggestion is that every time we meet with the union, with the employer to bargain on the contract, when that bargaining session is over, the union have a private meeting of the leadership or of the people who are on the bargaining team. And among other things, well, go over the meeting, what was good, what was bad, et cetera, what could have been better. But in addition to that, what was said at that bargaining session that we can follow up with a request for information, so that we come back to the employer and we say, well, at this bargaining session, you said that none of the this factory has the best benefits of any of the shops that are owned by the employer. It's got the best pension plan in the whole company. Well, if this was your assertion, consequently, we ask you to give us copies of the pension plans of all the other bargaining units in your company, so that we can see if it's true that we have the most generous pension plan, as you claimed at the bargaining session. So we follow up every grievance meeting, we follow up every bargaining session with a request for information. And if we don't get what we ask for, we don't just sit on that. We have got to then take it to the final step, which is to take the charge to the labor board to file a unfair labor practice charge and try to get the board to issue a complaint. This practice of constantly filing information requests, constantly asserting that the employer has failed to answer those requests, constantly reminding the employer, constantly going to the labor board, over time, you will educate the employer. And the employer will understand, hopefully, over time, that one, there is an area of law called union right to information. Two, that in almost all cases, the union is entitled to the information that it asks for. And three, if you don't give this union the information that it asks for, this union is going to take it further. It's going to give you a lot of trouble at the labor board. It's going to require you to get your lawyer. It's going to cost you money to defend, to defend yourself at the labor board. All right, let's go next. Let's go to the next screen. When can grievance information be requested? Timing. There are 4 stages where you might submit a request, and you might submit a request at all 4. So you might submit 4 requests. The first stage at which we're going to be looking at information requests is before we file the grievance, in order to monitor the workplace or to monitor the contract, or another word for that is to police the workplace or to police the contract. We have strong rights to demand information that we need in order to understand what is going on in this workplace, even if we're not in the course of filing a grievance, because this will tell us whether the employer is in fact adhering to the contract, is in fact fulfilling its obligation to have a safe workplace and to honor its obligations under the labor laws and the employment laws. Let's talk a little bit more about monitoring the workplace. Let me give you some examples, because I think many unions don't take advantage of their opportunities to submit information requests. For example, if we have a clause in our contract in which the employer agrees not to discriminate against workers on the basis of race or gender or age, well, how do we know whether the employer is following those requirements? We can't just wait for people to come to us with complaints. We want to be proactive. We want to search it out. So what kind of monitoring request. Well, for example, we might ask the employer to tell us the race and the nationality of all persons who applied for employment at the workplace, and the name and the gender and the race of the employee who got the job. In other words, we want to know how many minorities and women applied for jobs, and we want to know how many minorities and women obtained the jobs, because we may want to look into that to see if some legitimate people, whether the denials were in fact legitimate, or whether they were based on racial animus. We also would want to know how people are being paid in our bargaining unit. We would like to know for each employee the total salary, our wages and salaries received over the course of the last year. And we would like to know the number of hours that that worker was working, so that we can get a sense of whether that worker was paid correctly. We also would want written job descriptions for everyone in the bargaining unit. We would like to have the total hours worked each week for every employee over the past year. We would like to know the total overtime hours for each employee over the past year. We also want some basic information about the people. We would like to know their home address. We would like to know their email address. This is information which the employer must provide us. We'd also like to know if the employer has a suggestion box. We would like to have copies of all the suggestions that went into the box, so we can know whether they're good suggestions and whether the employer responded. We would like to have, if the employer has a formal evaluation system where every 3 months or every 6 months, workers are given are evaluated in writing, and that becomes part of their record. We would like to have copies of those evaluations to see whether there's any patterns there of bad evaluations for people from certain backgrounds, or bad evaluations by certain supervisors. We would also like to have a list of all discipline imposed on employees over the past, say, 6 months. We want to go through that discipline and see, did the employer follow progressive discipline? Did the employer pick out people? Did the employer have a pattern of excessive penalties for certain groups or certain types of employees? This is monitoring the workplace. This is policing the contract. This is information that we are entitled to before we even think about filing a particular grievance. In addition to this, we have an area which I call the what and the why, or the why and the what. That is, if an employer makes a decision, if a supervisor makes a decision to change the workload of a particular employee, to give him more assignments and to reduce the workload of another employee, well, that raises a question. Why did you do that? That's a question. That is a need for information. The why. In other words, employers make hundreds of decisions. So supervisors make, I don't know, scores of decisions every week, certainly, maybe more often. Those decisions affect employees, what their job are, what their assignments are, who they work with, what training they get. And in many cases, we don't know why they made that decision. Or the worker doesn't know why they made that decision. We have the right to insist that the employer give us an explanation of why they made a decision which has an impact on one of our members. We also have the right to ask the when question. If a worker is waiting to take a vacation and hasn't been told when he can have his vacation, he's obviously upset, or she's upset. He comes to the union. We're gonna go back to the employer and say, okay, he's entitled to time off, or FMLA, or other time off, or vacation. When is he going to be able to have his vacation? We'd like to know when are you going to let him have that vacation? That's a when question. These what questions and the when questions, these are all part of monitoring the workforce, monitoring the workplace. This is all part of information which the union is entitled to. I also would like to discuss with you, refer to something I call standing requests. Standing requests refer to actions which the employer is going to take in the future. And it's a request that says to the employer, if X happens, we want to be told about it promptly. So for example, an obvious standing request is if you impose a disciplinary penalty on an employee, we want to be told about it within 5 days, or within 3 days, or within 1 day. We need to have that information to know to help that worker respond. If a worker has a on-the-job accident, we want to know about it right away, because we're going to investigate it and decide why that accident occurred, whether we need to change training, machinery, etc. So we make a standing request. We are asking you to inform the union within 3 days of any employee who files a claim for workers' compensation or who notifies you of an on-the-job accident or condition. Subcontracts. We want to know when the employer subcontracts. We don't want to wait to have until people lose their job. So we put a standing request. We are submitting a standing request to you to notify us in any situation in which you hire an outside firm to do any of our work. And we want to be told about that within 3 days. So these are standing requests, and we should get good at those. And if the employer doesn't respond, ignores the request, or only provides a tiny amount of information, we complain about it. We remind the employer of the request, give them a second chance, because that helps our case at the board. Although we don't have to give the employer a second chance, but we do, because it does put us in a better posture. Then we take the case to the NLRB and say we have a standing request, the employer is ignoring it. Another type of monitoring that goes on, it has to do with temporary employees. That is, people show up in the shop, in the workplace, and they're doing our work. And we don't know, they're not permanent employees. They came from a temp agency, or they were hired off the street in some temporary capacity. They're not part of the union. They're not paying dues. Well, we don't like that. We're worried about that. If these people are doing our work, they should be in the union. They should be paying dues. So we want to monitor all temp employees. How do we monitor all temp employees? We ask the employer a standing request. If you hire a temporary employee, we want to be notified within 5 days of the name of the employee, the job title, the work that employee is going to be performing, the wage rate that employee is going to be given, the benefits that employee is going to be given. And we may also ask, if you hired that worker through a temp agency, we want to know the name of the temp agency, and if there were any rules that apply to that worker as a result of coming from the temp agency. So that's a long explanation for monitoring the workplace. The other parts of the grievance steps are a little easier. We're going to, if a worker comes to us with a complaint that he's not being paid properly, or she's not being paid properly, or she's been given assignments which are beyond her, what she's been trained for, etc. Well, we're going to investigate whether to file a grievance. Part of that is going to be submitting an information request. Third, to prepare for a grievance meeting. If we have a grievance meeting tomorrow, if we have a grievance meeting in a week, we will oftentimes submit a request to the employer for information that we want, and we instruct the employer to provide the information before the grievance meeting. We want to have the information several days before the grievance meeting so we can review it. But sometimes we only think of something late in the game, and the grievance meeting is tomorrow. In that case, we submit an information request, and we tell the employer, please bring this to the grievance meeting. Well, if you don't want to use the word please, we insist that you bring this to the grievance meeting tomorrow. And we have that right. And then the fourth step is to prepare for arbitration. Once we, if we get nowhere in the grievance process, we file for arbitration. We're having a formal proceeding. We're probably going to submit quite an extensive information request. We might want to go over that with whoever is going to be presenting the arbitration for the union, whether it's business agent or union lawyer. And we're going to be quite aggressive on each of those 4 stages. All right, let's go to the next slide. What can be requested? Well, in the general sense, you can say that we are entitled to 3 categories: documents, data, and facts. Let's go to the next slide. Examples of documents that we customarily ask for. Well, if we have an employee who has been reprimanded or disciplined for poor attendance or lateness, tardiness, we're certainly going to want to have the attendance records of that employee. That's a given. But we're probably also going to be asking for the attendance records of other employees in the bargaining unit or sometimes outside the bargaining unit in order to compare to see whether the employer is applying the same rules and standards or whether the employer is taking part in something which is called disparate treatment, which is a violation of just cause. Other types of documents which we are interested in getting oftentimes are contracts with subcontractors. Now, this is a tricky topic because we are not generally entitled to information about the economic dealings by our employer with outsiders. This is usually considered confidential information. So that it's usually quite difficult to get the contract with the subcontractor, because the contract will have the price. The contract will tell us how much the employer is paying the subcontractor. Either it's a lump sum or so much per employee or so much per hour. We're generally not able to get that information unless our contract is written in such a way that it says the employer is only allowed to subcontract when it can save money. In that case, we want to have the subcontractor see if he really is saving money. But the way to get the contracts with subcontractors is to make our request close to the next contract. So if our contract is running out in January of 2021, we are able to submit requests, say, in November of 2020 in preparation for bargaining in the next contract. And as part of that information request, we will be asking for the actual contracts with the subcontractors, because part of our goal in bargaining the new contract will be to recapture the work that has been going to the subcontractors. And to be able to do that intelligently, we need to know the amount of money involved, the amount of money that the employer is allocating to subcontractors, the amount of money the employer is saving or not saving by subcontracting. Third point on this list is customer complaints. A lot of times employer will assert that they got complaints about an employee from a customer. We want copies of those complaints. We're entitled to copies of those complaints. Employee evaluations, we're entitled to those. Insurance policies, we're entitled to. Interview notes. This is an interesting type of document. If we have, especially in a discipline case, the employer is going to be conducting some interviews to bolster its case. It's certainly going to be interviewing the employee, and it may well be interviewing several other witnesses. Are we entitled to the notes that the employer takes when he or she interviews those employees? The answer is absolutely yes. The employer must provide us with the raw copies of its interview notes, so we will know what information the employer obtained from those individuals. That will help us to decide whether we want to interview those individuals. It will also help us to know what information was in front of the employer when it made its decision to impose discipline. Did it have a good record? Did it have a lot of evidence? Or did it have very skimpy evidence or unreliable evidence? So we are demanding interview notes. By the way, we're entitled to the interview notes even if there was a union steward present at the interview. Certainly when the worker is interviewed, the union steward is there as part of the Weingarten rules to hear the questions and the answers, and is taking notes. So yes, we already have some notes of those interviews, but we want the employer's notes. We want the notes of the employer as he sat there and took his information. Why? Because we're going to look at those notes and we're going to see that they're very skimpy or they're wrong. And we're going to say to the employer, you made a decision to impose discipline based on your interviews, including this interview. But it turns out this interview is wrong. You didn't write down all the things that were said, or you wrote them down incorrectly. That puts a pall on your decision. Personnel files. We're going to want to have personnel files in many of our disciplinary cases. We're certainly going to want the personnel file of the worker who's been disciplined, but we're probably going to want the personnel files of several other employees who may have committed a similar type of misconduct but got a lesser penalty. That's part of proving disparate treatment. So the question arises, is the union entitled to the personnel files of other workers in the bargaining unit? Or are these files somehow confidential to the level that we're not entitled to them? The law is very strong here for unions. A union is to be trusted. A union is to be trusted with the personnel files of people in the bargaining unit. A union is to be trusted not to give those out and to embarrass the worker or to hurt the worker. And workers know that if they're in a union, workers should understand that their personnel files will possibly come to the attention of the union. So yes, we are entitled to the personnel file. And by the way, if the employer tells you you can have the personnel file of X, Y, and Z, as long as you give me their written authorization, we don't buy that one iota. We're not going to go to these workers and ask for their authorization when in fact, these are workers who oftentimes were given special treatment, favoritism by the employer, and they got a lesser penalty, and we're trying to bring that out. So we don't want to be in a situation where we have to go and get their signatures. So we have pressed that point with the labor board, and the labor board has agreed that a union cannot be expected to get written authorization from employees when it is trying to make a case of disparate treatment in particular. By the way, sometimes what the employer will do is they will go to the worker and they will say to that worker, you know, the union has asked for your personnel file. I'm happy to give it to them as long as you agree, as long as you approve. But if you tell me you don't want it to go to the union, then I'm not going to give it to them. That is an unfair labor practice. That is bargaining with individual employees. That is a ULP. We file a separate charge on that type of activity. That's direct bargaining. It's called direct dealing. It's illegal. There are hundreds of other personnel documents that we're entitled to. They're in the handbook. Everything from video. If the employer claims it has video of us, of one of our members doing something wrong, we want to see that video. Now, we're not necessarily entitled to a copy of that video. That's a kind of a funny lapse in the law. The employer doesn't have to make a copy of the video. That may have come into play when it was difficult to make copies of videos. But the employer certainly has to show us that video and allow us to study it privately, or at least with some privacy, before the case gets filed. Next, let's go to the next slide. The second big category that we ask for in grievance cases would be data. Data means statistics. Data is records. Data means the employer has to go to its files and do some work for us. Has to put together information, has to put together lists, has to put together information in a manageable, understandable form. So for example, if we have a worker who has been given a suspension for negligence, for poor work and for negligence, we're going to be asking for the names of every other employee who's been disciplined for that same offense over the past several years. We might go back 3 years, we might go back 5 years. We want the name of the employee who was disciplined, the date. We want to know the name of the supervisor, and we want a copy. We want a copy of the notice that was given to the employee notifying him or her that they are being disciplined for that offense. We want the original notice of discipline, because sometimes down the line that gets changed. It gets increased or it gets decreased. We want the original. We also, if we're doing a past practice case, and we are arguing that you are departing from past practice, that there's a consistent past practice of allowing people time off in the following circumstances. In the event of a serious of a death in the family, or in the event of that they need to go to school, they were elected to a union office and they want to go to a union training school. And you have always allowed people to do that. That's our argument for a past practice. The employer disputes that and says, "Oh, we do it sometimes. We haven't done it all the time." We want to know any incident in which they claim the past practice was not observed. Let's go to the next slide. Facts. We are allowed to submit factual requests, and we've already referred to them. A factual request is the name of somebody, the name of a witness, the name of a. Can we go back to that slide? Facts. Did we lose that? Facts. Names of witnesses, the names of complainants, dates, something that certain incidents that the company has referred to. What we're not allowed, what we're not entitled to as strongly as facts is opinions. So sometimes we would ask a question that seems to solicit from the employer its opinion. For instance, why do you feel that we're not entitled to time and a half on that holiday? What's your feeling about, in collective bargaining, we've asked for a pay increase of 10%. Why aren't you agreeing to that? These are not a request for facts. These are requests for opinions. Sometimes they're legal opinions. Sometimes they're personal opinions. Sometimes they're just some other type of opinion. And we're not entitled, we can't force an employer to tell us what its opinions are. We're only entitled to facts. Only the facts, ma'am. Finally, we'll go to the next slide and then we'll take some questions. Unions are also allowed to make general requests. So we're putting together a request for information. It might have 10 items. One of the requests might be for all documents that you relied on in making the decision to impose discipline. Another one might be all reasons that you made the decision to adopt the new attendance policy. So this is our general request. We don't know exactly what documents we're looking for or exist, but we're making a request for all documents which are relevant to the matter at issue. What we can't do is submit a request that says, give us a copy of every document that is relevant to the dispute, that is relevant to the discipline or relevant to the issue of as to whether you had the right to subcontract. So this general notion, give us everything that's relevant, that's considered to be not specific enough. Unions are expected to make requests in a specific fashion. So I think we can take some questions and answers if anybody has them before we go on.
They do. We're going to play 20 questions here, Bob. There are lots of questions in the Q&A box. And I'm going to start by summarizing a couple that I'm seeing come up a few times. And then for more unique ones, we may try to call on people to let you ask your question yourself. But no promises how the tech will go on that. But one I see several times people asking about is the timeline. What's a reasonable amount of time to expect a response to a request? What if the employer says they'll give us information, but then they take a long time getting back to us? Is there some deadline? Is there some financial penalty you can attach if they don't do it by specific date?
There is no hard and fast penalty. It would be nice if the board had enacted a rule that information should be submitted within 7 days or 10 days. Instead, what the board and the state labor boards do the same thing. they say that information must be submitted promptly, depending on the nature of the request and the difficulty in fulfilling it. So some requests legitimately take a lot of time to answer. It requires the employer to do a lot of digging in its records, maybe some interviewing, to maybe, for example, if you are looking for a document, you're having a dispute over subcontracting, the document that you want may be in the hands of the subcontractor. The subcontractor, he knows what he paid his wages. He has a list of the employees and the wages. The employer doesn't have that, but you want to have that information to pursue your grievance. So you ask the employer, tell us the wage rates paid to all the employees on the subcontract. Well, he doesn't have that. So but he has to help try to get the answer. And the rule is that he has to go to the subcontractor and submit a request. He has to request to the subcontractor for the information that you have asked for. Well, these are 2 or 3 steps here. And obviously it can take 3 days, 5 days, a week, 2 weeks, 3 weeks, perhaps, before that subcontractor responds. And maybe the employer has to send 2 letters to the subcontractor, all these different situations. So there is no hard and fast. But on the other hand, there are some documents which are readily available, meaning that all the employer has to do is go to its computer and print and hit the document. The personnel file pops up and you hit copy, or you copy certain pages. If you want the notice of discipline that was given to Susie Summers concerning lateness, that's a 1-page document. It's in her file. The employer can get it within seconds. Almost all employers have put the personnel information electronically. So that's a few minutes. So certainly if you make a request for a readily available document, which the employer can produce easily and quickly without any significant expense, well, then there's no excuse not to provide that information within 2 or 3 days. At the most, 5 days, a week. So I would say, just as a rule of thumb, I would ask for the information to be provided within a week, maybe within 2 weeks. It was a little more complicated. And if you don't get the information, I would send a reminder. I would wait a couple of days, and then I would go to the NLRB. At some point, we need to go to the NLRB, and we need to have an NLRB agent explain to the employer its obligations to respond in a prompt and diligent fashion. And we can only get that to happen if we file charges. Next.
Another question that's come up several times is, can you request information on people who are not members of the bargaining unit, for instance, non-union workers, members of another union, members of management? Someone says, I've frequently been denied information, particularly about members of management, because they're not in our union.
Yeah. Good question. Generally, the answer is no. Generally, we're only entitled to information which is relevant to working conditions or pay, or benefits or pay of our members, of people in the bargaining unit. Generally, that information about supervisors and managers is not considered relevant to any legitimate need of the union. However, there's a big exception, and the big exception occurs when an employee is disciplined for conduct. And we know that a member of management, of supervision, has committed the same misconduct and has received probably no discipline or very minor discipline. Certainly wasn't fired because he's still on the job. So take an example. An employee comes to work and he's intoxicated. And he shows up at the gate and he comes in and the employer notices it, talks to him, and fires him on the spot. It's a dischargeable offense. Well, we're filing this grievance. We want the best way to win a disciplinary grievance, to be honest with you, is to prove disparate treatment. We look around, we can't find any other employee in the bargaining unit who had the same fact pattern, showed up drunk and was given no penalty or a very minor penalty. We do a search, but we know it doesn't exist. However, we do know of 1 or 2 supervisors who showed up intoxicated and were just sent home, and they're still on the job. Maybe they were sent to some kind of school counseling, we don't know, but they're on the job. They weren't fired. Our guy was fired. That looks like disparate treatment. In order to make that case, though, we need the facts. So we need to know we need to ask the employer for the name of of any employees in supervision or any employees outside the bargaining unit who committed the same offense, that is, came to work intoxicated, and were given a lesser penalty than discharge. And and if so, give us the name of the employee, the date, and a description of what happened. And once we get that information, we want the personnel file of that employee, because we want to know what happened. We want to know, well, maybe he was suspended for 30 days. That would weaken our case. Even though we have a guy who was fired for drinking, and there's a supervisor who got 30 days, those are two severe penalties. Not that big a difference. It's a difference, but it's not, maybe not be enough for us to win the case. But in many of these cases, we find the supervisor just gets a slap on the wrist. Well, at most is sent to counseling. In that case, we have a good case. We have one employee fired. We have another employee who did the same thing or close to the same thing, who got a minor slap on the wrist. So yes, we're entitled to information about people outside the bargaining unit who committed the same offense and got lesser penalties. The only difference would be the only necessity we have is that we can only do this if the misconduct that the supervisor engaged in, if the rule that our member was penalized for applied to the supervisor. There has to be a rule that applies both to employees and to supervisors. And many of the rules are. Certainly the rule against coming to work intoxicated applies both to supervision and to rank and file. But there are some rules that only apply to rank and file. For instance, signing in, or punching a time clock. That's a rule that only applies probably to the bargaining unit. Doesn't apply to management. Or even some of the rules on attendance and lateness. Sometimes supervisors are not held to the same rules on lateness, because after all, they come to work late, they may work late and make up for it. That may be the way that's okay, So there's some rules that we can't get the information about management. But when the rule is one which both groups are subject to, then we are entitled to it. And we've won a lot of cases. We have won a lot of cases by, you take a case like fighting. A lot of times we're representing an employee who gets involved in a physical altercation and is given a very stiff penalty, maybe a discharge. We look around the bargaining unit, we can't find anybody who did the same thing and got got no penalty or minor penalty. But there are people in supervision who get involved in altercations, either among themselves or with our own members. Sometimes they lash out at our own members and kick them or hit them or push them and get no penalty or just a slap on the wrist. We can win a serious case that way. We can win a case of even when a worker physically assaults another worker, we can win that case if management did the same thing. Next.
All right, this one I'm going to empower the person to ask their own question. Yesenia Godinez, go ahead.
Mr. Schwartz, thank you so much. Can you hear me okay?
Yes, perfect.
Okay, great. First of all, thank you so much for everything you've done. I'm a huge fan, and I've been doing union rep work for over 10 years. So thank you so much. I'm very, very appreciative of your work, and you're one of the first books I read when I was pulled into union work. So first of all, thank you so, so much. I love the way you write, and it's very clear to understand. So thank you.
Oh, good. And I have good editors too. Labor Notes gives me very good editors. One of them is right over there.
Thank you, Bob. Thank you so, so much. So my question is this: I deal with a very bad boss, and a couple of things I ask, but one of the things, just a very simple thing. When I do an RFI, most of the times I do it and I say, in order to investigate a grievance, we need this information. What would you suggest to write when you talk about policing the workplace? How would you word that? Because that's not necessarily investigating an individual grievance. Does that make sense?
I think you can just use those words. In order to monitor the workplace, the union requests the following information.
And that should be enough for them?
Yes, yes. It's
Okay.
the notion of monitoring or policing the workplace is well recognized. And anybody in human relations, they know that that's a legitimate basis for a union information request. They should know that.
Okay, so just say in order to monitor the workplace under the guidelines of our CBA or something like that?
Yes.
Okay,
Yes.
great.
That's good.
Okay, awesome. Thank
And
you.
by the way, when we're talking about information requests, one thing that's interesting, when you submit your request for information, you have a choice as to how you put it. You can say, please provide the union with the following information. Well, we request that you provide the union with the following information. But you can also be more adamant. You can say, the union, in regards to the grievance of Goldberg, we demand that you provide us with the following information. Or we insist that you provide us with the following information. You can
Right.
phrase the request any way you want. The point gets across. You want this information. You don't have to say please. You don't have to say request. You don't have to. You can be more aggressive if you want. If you feel that fits
Right.
your case in a stronger way.
Okay, thank you very much.
Next.
Let's see. Kim McCarthy, do you want to ask your question aloud?
Can you hear me? I don't have my mic on.
Yes, we hear you. Go ahead.
Okay. Thank you so much for this webinar. It's incredibly helpful. I am the president of a teachers union, and I'm wondering what kinds of restrictions on information requests might be applicable when students who are minors are involved. For example, student records or interview notes.
Good. All right. I think that actually leads to a very important topic, which I definitely want to cover as a part of the presentation, which is the topic of confidentiality. So if we can go on, Al, can you move to the screen that says confidentiality? Do you see it? It's about 3 or 4 ahead of us. The one before that. Good. Okay. Let's talk about confidentiality. It comes up in 50% of information requests. The most common basis for an employer to deny a union request for information is to claim that in some way the information is confidential. Either it's confidential to the employer, it's confidential to the employee, to an employee, or in the case that you just referred to, I think they would say it's confidential to a student, or if you're in a hospital and we're asking for patient records, they're obviously going to say it's confidential to the patient. And on that basis, they won't give us the records. And in many cases, the employer, the union folds at that point, but that's a mistake. That confidentiality is not as strong a defense as the employer believes. First of all, let's talk a little bit about what kinds of employer records might be, would be confidential. Well, it's possible that trade secrets are confidential, because if a trade secret is provided to the union and it gets out to the public, I suppose it could lead to a competitor making the product. Profit levels are considered confidential, highly sensitive. Ongoing investigations are sensitive, and documents prepared by the employer's attorney. These are records which are in fact confidential. So by the way, ongoing investigation is interesting. If a worker is called in for a Weingarten interview because the employer is investigating whether that worker committed some type of harassment, theft, or some other, and the union is going to be there taking part in the interview, they know that the employer is investigating this employee. can the union at that point make demands for the records of the employee, of the employer? Tell us why you're investigating. Tell us all records related to the investigation. Give us copies of any witness reports that you have. These are all sensible requests. However, this is an ongoing investigation. The employer has not determined to take action against the worker. And the board's rule is that that is too confidential. That's confidential. That is, the employer needs to have some type of security to know that he can conduct an investigation without it being, quote, sabotaged by the union before it even gets started. The employer needs to be able to conduct its investigation, make a decision, then give the records to the union and let the union challenge it. Also, any documents prepared that come from the lawyer for the employer, those are certainly confidential. When it comes to records from the that relate to employees, certainly medical records, the employer has a legitimate basis to argue are confidential, at least if it's medical records that are embarrassing. Not all of medical records are embarrassing. For instance, certainly diagnosis of HIV, that yes, that's embarrassing. That could be embarrassing, could be harmful if it gets out. But the fact that an employee has had the flu, now COVID I haven't seen any rulings on COVID, but you could say that certain medical records, including COVID, are highly personal to employees and therefore confidential. Certainly aptitude scores, if we are fighting a promotion that the wrong worker got promoted and they say, well, the worker, he had the best aptitude scores, or the guy you're representing had a bad aptitude score. We want that. No, aptitude scores are personal and confidential. So it comes up all the time. Let's go to the next screen. When an employer asserts confidentiality, this is how we should respond. We have basically 4 ways of arguing with the employer. First, we say, no, that information is not confidential. You claim it to be confidential. It's not confidential because everybody knows about it. The worker doesn't consider it confidential. The worker has told everybody else that he has HIV. It's just not confidential. That's one argument you can make. 2, if it is confidential, you are able to argue that, okay, it may be confidential, but our need for the information outweighs your need to protect confidentiality. It's a balancing test. And the board says that the employer must go through a balancing test. And if the union's need seriously outweighs the employer's need, even if it's confidential, it should be supplied. But these are difficult arguments to make. It's not precise. Third thing, we can agree that the confidential information can be removed or redacted from the personnel file. So if we ask for a personnel file, it's got medical information, it's got aptitude information, and the employer says, I'm not giving it to you because it's got confidential information. Well, oftentimes we'll just get over that by saying, take it out. We don't need the medical information. We don't need the aptitude information. But here's the killer. Here's the best way to overcome confidentiality. We offer to sign a confidentiality agreement. A confidentiality agreement is a promise on our part that the records which you're going to give us, we will keep them private. We will not distribute them. We will not give it to people who aren't part of our inner circle. We will keep them private. They will not get out. They will not embarrass you as an employer. They will not get to your competitors. They will not embarrass other employees. We are offering to sign a good confidentiality agreement. Now, a lot of times unions are shy about doing that. They think somehow that's a sign of weakness. I don't see it as a sign of weakness. I think it's a sign of being smart, because in fact, we don't need to publicize this information. The information we get from the employer is part of the arguing grievances or even collective bargaining. We're not interested in putting it out in the New York Times or the Boston Globe or whatever. We want to use it as part of our arguments in the grievance process or at the bargaining table. So it's not such a big deal to sign a confidentiality agreement in which you promise that this information will only be distributed to the union officers and the grievant or the union bargaining team, and it will not be in any way given out or used otherwise. Now, sometimes the employer's response is, oh, you're willing to sign a confidentiality agreement. That's too bad for me. But we need to have things in that agreement to make it a really tough agreement. And the way they approach it a lot of times is through the penalty part. They say, you're promising to keep the information private, but there's no penalty on you. So we need to have a provision in the confidentiality agreement that says that, they call this liquidated damages. That says that if the union breaches the agreement and does tell other workers or tell other employers about, or the public, that they will pay a fine of $1,000, $10,000. And of course, we don't want that. In that case, we're going to challenge the employer at the NLRB, because the rule is that an employer can only require us to sign a reasonable confidentiality agreement. Reasonable. And if confidentiality agreement that imposes a serious penalty on the union for conduct that is hardly likely to happen, it's not reasonable. It's unreasonable. In that case, we probably would go down to the NLRB and say, look, they're trying to make us sign a ridiculous confidentiality agreement. It's not reasonable. We want you to issue to charge them with an unfair labor practice. Let me move on to the next screen, and then we'll take some more questions. Another basis for refusing our request in the last few years has been a claim that the document or the information which the union is asking for is protected against disclosure by a law called HIPAA, which is a federal law. And the long name is Health Insurance Portability Accountability Act. And the employer says, that law says we cannot give out healthcare information of one of our employees without the patient's authorization. Now, in 90% of those cases, the employer is distorting the law. Why do I say that? First of all, if you read HIPAA, even not so carefully, you see that it only applies, it's only a restraint on healthcare providers, not manufacturers, not schools, not city agencies. It forbids healthcare providers, that's what's in the law, from disclosing protected health information without patient authorization. Who's a healthcare provider? That's a hospital, a doctor, a health plan. Well, okay, but we're a health plan, we're a hospital. We are SEIU, and we represent the nurses at Mass General Hospital, and we have a nurse who is charged with patient abuse. The patient is claiming that the nurse pushed her head down to eat in a very abusive manner. And we have a nurse who has been threatened or has been fired for patient abuse. We want the medical records of that patient, because we think those records will probably show that that patient has made claims against many people in the hospital without basis, over and over again. Well, we feel those medical records will disclose that this patient has a mental condition, has a condition that leads to exaggeration or whatever. So we have a legitimate reason to want those records. The HIPAA law says that there's an exception in the law if the disclosure is needed to resolve an internal grievance. Well, that's exactly why the union is asking for the information, to resolve an internal grievance. The HIPAA law has another exception that says that it doesn't apply to a disclosure required by law. Well, according to the National Labor Relations Act, you have to give us those medical records because they're relevant to the union's grievance. And if the union is willing to sign a confidentiality agreement with that they will keep the information confidential within the grievance process, then it is required by law. So don't let yourself get bamboozled by HIPAA. 95% of the time, it's not a defense, it doesn't work. We'll take that to the NLRB, and we would expect the NLRB to take our position. Of course, we know that right now the NLRB is hardly ever taking union positions, but there could well be a big change, as we all know, in a couple of months, at least the beginning of a big change. And we start to see some new people at the NLRB, and that they take the union interests a little more seriously. So that finishes the presentation. We can take a couple of more questions.
Okay, the next question comes from Jennifer Whiston. Go ahead, Jennifer.
Hi, thank you so much. Can you hear me?
Yes.
Yeah.
Okay, great. I have some questions about requests for information regarding a return to work policy following COVID. I can give you the specifics, but it's just we're more concerned. Obviously, there isn't a lot of history to it since it's a new thing, but it's kind of interesting.
Well, there's a lot of, I think there's probably a lot of questions on that deal with COVID that apply to requests for information. I'm not sure exactly what the request that you're asking for from the employer is, but I certainly have heard, obviously many employers are refusing to give unions the names of employees who have come down with COVID because the union wants the names so they can alert everybody else in that department. What you're referring to is you want to know what the union's policies are in regards to
well,
how they're going to respond to employees coming out positive.
Forced back into the office faster than the pandemic, the plans the state and federal laws are allowing, but they're kind of standing by it also because our contract was signed during the pandemic, so we're just having some issues with exactly what to ask.
Well, I guess it's that's a kind of a hard question. First of all, the NLRB, as far as the NLRB is concerned, and you may not come under the NLRB, you may come under a state board, but the NLRB takes a very relaxed view towards bargaining during the pandemic. They are taking the position that this is a crisis, it's an emergency, and that they looked at some old case law that says when you have a flood, when you have a tornado, the employee can make decisions without notifying the union or bargaining with the union. And this is the board is applying that to COVID decisions, so decisions related to COVID. So that becomes very complicated to talk about how that should end up. I do want to say one thing about this question of the name of the employee who came down with COVID, or an employee who is test positive with COVID. And we want that name. And the employee doesn't want to give us that name. So how do we get that name? Well, the answer is we offer to sign a confidentiality agreement. The information is confidential, or it's very close to being confidential. It's information which is personal to the employee. It could be embarrassing. It could harm the employee. If other workers find out about it, it could be humiliating in some way. So it is confidential. However, we are willing to sign an agreement with you that the name of that employee's name will not be published, will not be in any union publications. It will be confined solely to the union president and vice president or the chief steward. We will not be letting it get out in any way that would be harmful to the employee. After all, the employee is a member of our union. We're not trying to hurt that employee. That's how I would approach it. Confidentiality agreement.
All right, next question is from Zachary Knight. Zachary, do you want to go ahead and ask your question?
Hi, thank you. My question is kind of a general one, so touch on what you may, but I have seen a number of information requests coming from employers asking for a variety of things. And what we're struggling with is figuring out where the line is between a reasonable request and the union's right to, I guess, avoid employer surveillance and protect our internal records. So just a general question, what can they request and what are we obliged to share?
Well, okay. Certainly, the more active we are in making information requests, the more frequently we use this technique. We're seeing that employers are responding in kind. They're saying, well, if you do it, we'll do it. So yes, many times the more requests we make, the more requests they make. And some of the requests that come from them are difficult to respond to, or we don't want to respond to them. But we have some defenses. First of all, we don't have to provide them with any information about any subject that is not a mandatory subject of bargaining. The information request rubric only applies to topics which are mandatory subject of bargaining. If it's what they call a permissive subject of bargaining, such as internal union procedures or rules, these are not mandatory subjects of bargaining. We don't have to bargain with the employer as to how much we charge people in dues, or what our rules are if you don't pay, or what our penalties are if you cross a picket line. These are internal union issues, not mandatory subjects of bargaining. Union has no right to even ask about them. Second, in many cases, the employer asks for information, especially in the grievance process. We might start it out, we ask for the employer's investigative file. This is the way I see it. The union reads in my handbook or some other place that their union is entitled to the employer's investigative file, including interview notes, witness statements, names of records consulted, recommendations, etc. So we ask for the employer's investigative file because we know that the board has said we're entitled to it. The employer comes back at us and asks for the union's grievance file, because within the grievance file is our notes, our interview notes, our what we've written down as to whether we think the contract was violated. Do we have to give them? Now you could say, well, it seems like it's a parallel thing. You can get their investigative file. They should be able to get your grievance file. But the board doesn't say that. The board makes a distinction. Records which are prepared by a party in anticipation of litigation, that's the phrase, anticipation of litigation, are considered work product. If a document is part of a work product, it does not have to be disclosed. Everything in the union's file is prepared in anticipation of litigation. If you consider the grievance process litigation, and it is. So everything that we prepare in our grievance file, we prepare it in order to present it, at a grievance or to present it at an arbitration. It's all work product, and consequently, it's all privileged. We don't have to provide it. The employer's investigative file was not prepared for the grievance process or for arbitration. The employer prepares an investigative file to determine whether to impose discipline, a day-to-day decision, a business decision. He doesn't assemble an investigative file for a grievance or for arbitration. He prepares it not for litigation, but for business decision. Consequently, he cannot claim work product, but we can claim work product. And that's the best argument that we have to avoid providing the employer with information or records which we want to keep private, as well as the argument that the request relates to a permissive subject of bargaining, which is a little more technical, but it's a good one. Oh.
Here's a question I'll read. With Trump in office, do you know of any pending changes, or do you anticipate any changes regarding information requests at the NLRB?
No, I mean, the NLRB, they sometimes telegraph the changes they're going to make. Sometimes they announce, we're thinking about making a change here. We solicit input from the parties. What do you think about getting rid of the contract bar rule? That's the most recent time this came up. But they haven't done that, and they did that with a few they did that when they changed the rules regarding profanity. And maybe you've read the article I wrote in Labor Notes. They've enacted a whole new set of rules forbidding union stewards and officers from engaging in profanity in the course of grievance meetings. It's crazy, but they announced it in advance that they wanted to make that change. They haven't done that for information requests. The one I would be, and I don't anticipate anything big before November, but what I would worry about if Trump stays in office and he continues to control the NLRB, they will continue to make many incredibly bad decisions. One might well be that unions are not going to be allowed to get information if the union files an information request in the course of the grievance process, the board will defer that to arbitration. In other words, they will say, take this to an arbitrator. You're in the middle of a grievance process. You have the option to take this to an arbitrator. Take it to an arbitrator. See what the arbitrator says. See if the arbitrator orders them to give you the information, then come back to us. That's deferral. And that would be terrible. That would be unworkable from our point of view, and would take away all leverage we have to get this information. So that's what I would worry about.
Here's an anonymous question. Person says, I am a steward representing federal employees. How do Privacy Act considerations affect requests for information in the federal context? And what requests for information would scare my management most, do you think?
Well, I don't know if I can answer the last one without knowing a little bit more, but it's true. There is a federal law called the Federal Privacy Act, which does apply to federal employees. However, I'm almost certain it has an exception for documents which must be provided by law, documents which are subject to a legal obligation to disclose. And certainly grievance-related documents would fall within that exception. So it shouldn't be a problem. The Federal Privacy Act, I don't believe, shields an employer from providing information that the union needs in the grievance or the process or collective bargaining.
Here are two I'm going to put together. Can we request the personnel file of a supervisor who's been harassing a member? And can we ask for information of whether management completed anger management they were ordered to complete?
Well, I think the second one, yes. I mean, if the employer says, well, yeah, the supervisor did assault an employee, yeah, but we put him in an anger management program. Well, I think and then we come back and, well, how did that resolve? Did he finish the program? That's a legitimate question. That you need that information to know what the penalty was on this, whether there was a real penalty on this supervisor, even a minor penalty. But the first part of your question, I think, was different. The first part was,
can we request the personnel file of a supervisor who's harassing a member?
Well, we're not allowed, yes and no. We would have to have, okay, first of all, we would have to have objective proof that the supervisor committed the same type of misconduct and was given a significantly lower penalty. Okay, that's a prerequisite. We have a supervisor who was smoking in the non-smoking area. We have witnesses. He wasn't fired. He wasn't suspended. We want his personnel file to see what penalty was imposed on him, if any. And that's in that context, the employer would have to give the personnel file, or at least that part of the personnel file that relates to discipline. So maybe the employer would be able to hold back. There might be other stuff in the personnel file about that supervisor, his private life, his marital life, who knows? But the disciplinary portion of the personnel file, that would have to go to the union so that the union could make a judgment as to whether the employer has imposed disparate treatment.
All right, here's a question from Renata Peralta. Renata, you want to go ahead and ask your question? Renata, are you there?
Both my questions are answered already.
Okay, great. Let's see. How about okay, here's one from Nick D. Let me just find you on the list. Go ahead, Nick.
He's obviously a very aggressive steward.
Nick, are you there? You want to ask your question?
Yep, sorry, I was talking to myself apparently. I think you already answered this question, but I'll ask anyway. Can a steward request information during a Weingarten meeting of that employee that's being disciplined?
Well, there aren't too many rulings on that. What rulings I've seen would point to the answer being no. The general feeling is that the union is entitled to information, that an employer should be able to conduct an investigation unimpeded, so to speak, by union interference. Once the employer makes its decision, then all the information has to be disclosed. But until the employer makes its decision, it's still in the throes of an investigation, and the union wouldn't have the ability to disrupt it, interfere with it, or even affect it.
Thank you.
All right. How about Andreas? Andreas Thompson, go ahead.
All right. The question I had is, we received all new management. They're trying to say past practices no longer exist under that with the new management.
Well, that's that's a question for perhaps the next workshop. If we do a workshop on past practice, which we might, we would definitely discuss that. But the general rule is that management, if there's a past practice in a facility that provides a significant benefit for employees, it's enforceable even if management changes supervision, even if a new supervisor comes into the department, even if a new general manager takes charge of a facility, even if a new owner buys the company, the pre-existing practices are still binding on the employer in the same way they were beforehand. So if it was a binding past practice, and that's a complicated question because not every past practice is binding, but if it fits the definition of a binding past practice, you have to read my handbook on past practice. If it fits the definition of a binding past practice, it continues even if supervision changes.
Dawn Baker, you want to ask yours? Dawn, are you there? I'll go ahead and read it. The question is, what happens when the Labor Relations Department is staffed with attorneys? Can they then declare confidentiality?
Well, they will declare confidentiality. They'll also call it attorney-client privilege, and they will try to say that all the communications within the department or memos that went from the lawyer to the suit to HR, they will try to say those are all privileged from disclosure to the union because one of the person who wrote the memo or the person who got the memo is an attorney. And that can be a problem. What the cases I've seen, one time there was the head of labor relations, he had a law degree. And he claimed that therefore, because he had a law degree, everything that he wrote was attorney-client privilege, was protected from disclosure because he was an attorney. But the board said, no, you may have a law degree, but you're not functioning as a lawyer. You're not functioning as an attorney. You're functioning as a labor relations, as an HR person. That's all you function. You don't go to court. You don't write briefs. You don't give legal opinions. So in that case, they didn't apply attorney-client protections. So, but the example you gave is a little stronger. Everybody in the HR department is a lawyer. Some of them may be functioning as lawyers. If they're functioning as a lawyer, they're lawyers.
Here's one. I can't find the person, but I'll go ahead and pose the question. Can you speak to, are people entitled to information if they're leading up to bargaining a first contract and don't have a contract yet? For instance, information about disciplines, kind of thing you've been describing.
If they're bargaining a first contract and they would like to have records relating to the discipline of employees over the past couple of years or something like that?
Yeah.
Well, the question is why do they want the information? I mean, it's not for a case or a grievance. It's in order to negotiate the just cause, a just cause clause. That's probably why they would want, if they're going to have to negotiate a discipline clause in the new contract. Probably it'll be just cause or good cause or whatever. In order to do that intelligently, the union would say, we need to know the level of discipline that occurs in the establishment, the types of cases that discipline is applied to. I mean, if you can make a case that you need the information in order to intelligently bargain on the just cause clause, then you're entitled to that information. Yes. But you have to link it. You have to link it. It doesn't strike me that's always linked, but you have to try to link it.
Here's something a few people were asking in the chat box and the Q&A. Can they get your PowerPoints?
Oh, sure.
You...
You have it. You have it. You can get it from
Great. All right.
David.
I'll send it out tomorrow to everybody who's registered for the webinar. We'll figure out a way, send a link or post it or something along those lines. Okay. What do you think? More questions, Mr. Schwartz, or how are you doing?
Well, I don't want to kill anybody.
There are more in the box if you're up for it.
I think we covered a lot of ground tonight, and I want to make sure I get some liquid refreshment. So I think we'll take a break here.
All right. Well, thanks everyone so much for coming. Once more, the book, Chapter 4 of the Legal Rights of Union Stewards, deals with information requests, and you can get this book at labornotes.org. Robert M. Schwartz, our illustrious speaker, thank you so much. Round of applause, even though we can't hear each other. Thanks very much.
Thank you for stepping in with as the moderator.
All right, everyone. So we'll send out an email with that PowerPoint and with the video. This has also been broadcast on Facebook tonight, so you can share it with your friends. Come back and listen in again, and this series may continue next month. Thanks and good night.
Okay.